The judge's order arrived on a Tuesday morning, and the number printed on it was larger than the check my boyfriend's father had slid across his desk 3 months earlier. I know because he called me that afternoon, not to argue, not to threaten, but to say 3 words I hadn't expected from a man who had spent 60 years never saying them to anyone. But I'm getting ahead of myself. I was 28 years old and 8 weeks pregnant when my boyfriend's father asked to meet me privately. Not my boyfriend, not his mother, his father. His assistant sent the calendar invite to my work email, which told me everything I needed to know about how seriously they had already mapped this situation out before I even walked through their door. I'm an ER nurse. I've been one since I was 23, first in Indianapolis where I grew up, then in Chicago after I transferred to a level 1 trauma center on the north side. I've held the hand of a 19-year-old who didn't make it. I've talked a man out of pulling a staple gun trigger in triage. I've worked 14-hour shifts on 3 hours of sleep and still driven home without crying until I got to my building's parking garage. I don't say this to sound impressive. I say it because when people like my boyfriend's father miscalculate someone, it usually starts with underestimating exactly this: what a woman who has spent years in controlled chaos actually looks like up close. My boyfriend and I had been together for almost 2 years. We met at a charity auction for a pediatric hospital unit where I'd volunteered to help check in donors. He was there with his family, moving through the room with the practiced ease of someone who had been attending events like that since childhood. He stopped at the check-in table longer than necessary. He came back 3 times on the pretense of different questions. By the end of the night, he'd asked for my number. By the end of the month, we were having dinner twice a week. His family owned a commercial real estate development company, the kind that has its name on buildings rather than on plaques inside them. His father had built it from a regional firm into something national over 40 years. His mother sat on 2 nonprofit boards. My boyfriend ran the firm's technology investments, which was a polite way of saying he spent other people's capital on ideas he found interesting. He was 34 and good-looking in the way that men who've never had to try very hard often are. He was also, genuinely, kind to me. That part mattered, and it made everything that followed harder. When I told him I was pregnant, he went quiet in a way that was different from thinking. It was the quiet of someone running calculations. He reached across the table and held my hand. "I'll talk to my dad," he said. He said it like it was the most natural thing in the world, like his father was a resource rather than a parent. I remember thinking that was strange. I was 28 years old and the idea of calling my own father first hadn't even occurred to me. The meeting was at his father's office in a glass tower on Michigan Avenue, 41st floor, panoramic view of the lake, the kind of office that communicates its own importance before anyone inside it says a word. His father stood when I entered, which I would later understand was a calibrated gesture. He was in his mid-60s, trim, silver-haired, a man who made every motion look considered. "Please, sit down," he said. We sat. He didn't circle anything. He opened a leather portfolio on the desk and slid a single document across to me. Beneath it, face down, was a check. I could see the zeros through the paper. I didn't reach for either. "My son has shared the situation with me," he said. "And I want to be clear that I have the deepest respect for you personally. This is not a reflection of your character." I waited. He continued. "My son is in the middle of leading a significant capital raise. The timing of a public paternity matter would create complications that are frankly unnecessary. I'm prepared to offer you a resolution that is both private and generous." He flipped the check over. $3 million. Beneath it was an NDA, maybe 40 pages, already tabbed for signature. "There's also a clinic appointment scheduled for Friday," he said. "Everything has been arranged discreetly. Afterward, the transfer would clear within 24 hours. He used the word discreetly the way some people use the word unfortunately, like a softener that was supposed to make the thing it was attached to feel reasonable. I looked at the check for a moment. Then I looked at him. "What exactly are you asking me to do?" I said. He held my gaze. "I'm asking you to consider what's best for everyone involved, including yourself. You're young. You have a career. This doesn't have to define the next 20 years of your life." I picked up the folder. Not the check, just the folder. "Thank you for your time," I said. He blinked. "Is that a yes?" I smiled. "I'll be in touch." He thought I was being practical. I could see it in the slight release of tension around his eyes. He thought I was a sensible woman who understood how the world worked. He had no idea that I'd spent the previous 72 hours on the phone with a family law attorney whose number I'd gotten from another nurse in my unit whose sister had gone through a custody dispute 2 years prior. Her name was my attorney. She was 51 years old, a former public defender turned family law specialist, and she had the calm, unhurried manner of someone who understood that panic was a choice. She answered my first call at 6:30 in the morning without complaint. I met with her the morning after my boyfriend's father's office. I brought the folder. She read every page while I sat across from her with a cup of coffee going cold between my hands. They've drafted this to waive all future paternity claims, financial support, inheritance rights, and any public disclosure of the relationship, she said. This clause here would also prevent you from discussing the pregnancy itself. He called it discreet, I said. She looked at me over her reading glasses. It's a permanent gag order attached to a one-time payment designed to feel enormous. Is it? She set down the folder and folded her hands. In this state, child support for high-earning parents is calculated based on verified income, including business distributions, equity compensation, and investment returns. She paused. For someone at your boyfriend's income level, the projected obligation over 18 years is not $3 million. I leaned forward slightly. How much? She gave me a number. It was substantially higher. More than that, she said. It's enforceable. It adjusts with income. It can be modified. It has judicial oversight. A private settlement, once signed, is closed. A court order stays open. What do I need to do? File first, she said. Once a paternity petition is entered in family court, the matter is under state jurisdiction. They can't move it to private arbitration. They can't seal it without a judge's approval. They lose the ability to dictate the terms. When? Tomorrow, if you're ready. I was ready. The family court building was nothing like the office on Michigan Avenue. No lake views, no leather portfolios, plastic chairs bolted to linoleum floors, a security line that moved slowly, the low hum of fluorescent overhead lights. A teenage girl doing homework on a backpack balanced across her knees. 2 men in work jackets sitting with paperwork neither one appeared to understand. My attorney moved through the space the way she moved through everything, without hurry, without performance. Are you certain? She asked quietly while we waited for the clerk's window. I thought about my mother, who had raised me and my 2 brothers in a house outside Indianapolis after my father left when I was 11. She worked nights at a distribution warehouse for 6 years so I could do extracurriculars. She never complained. She never said a word to us about the choice she'd made or what it had cost her. What she did do was show up. Every time, without fail, she showed up. I nodded. My attorney handed the filing to the clerk. Petition to establish paternity. Motion for DNA testing. Request for financial disclosure. The clerk stamped it without looking up. That sound, a single firm thud of a government stamp, landed in my chest somewhere quiet and certain. They'll be served this afternoon, my attorney said as we walked out. My boyfriend called me that evening. Not his father, my boyfriend. His voice was low and flat, the voice of someone delivering news he hadn't wanted to carry. My father says you filed, he said. I did. A silence. Why didn't you just tell me? I would have talked to him. You already talked to him, I said. That's what produced the clinic appointment, he exhaled. This is going to be public. It's already court record, I said. The difference is it's also protected now, by a judge. Another silence. Longer this time. My father is furious, he said finally. I let that sit for a moment. Then I said, your father offered me $3 million to have a medical procedure I didn't want. I filed a legal petition instead. One of those 2 things is a problem. It isn't mine. He didn't answer that. I sat on my couch after we hung up and placed both hands over my stomach. 8 weeks is nothing visible. No movement, no shape, just a possibility that had become a fact. I thought about the $3 million check still in the folder on my kitchen counter. I thought about what it would feel like to deposit it. The relief of it, immediate and enormous. The silence that would follow. The kind of silence you can't undo. I've seen what happens when people take the private payout. I've watched it in the ER, not financially but emotionally. The women who signed something to keep a situation quiet and then spent years living inside an agreement they couldn't escape. Silence purchased isn't peace. It's just a different kind of confinement. I put the folder in a kitchen drawer and didn't open it again. The preliminary hearing was scheduled for 3 weeks after we filed. My boyfriend's father arrived with 2 attorneys from a firm whose name I recognized from billboards near the courthouse. He wore charcoal gray and didn't look at me when he entered. My boyfriend sat beside him. He looked like he hadn't slept. The judge was a woman in her early 60s, compact and precise, the kind of person who has heard every version of every story and is no longer impressed by any of them. She reviewed the filing without expression. "Petition to establish paternity," she said. "Motion for DNA testing. Request for full financial disclosure including salary, bonuses, equity distributions, and trust income. Is there any dispute as to potential paternity?" My boyfriend's attorney stood. "No, Your Honor. No theater, no outrage, just acknowledgement." The judge ordered DNA testing within 14 days. She ordered financial disclosure documentation to be submitted within 30 days. She addressed the motion for private arbitration my boyfriend's father's attorneys had filed the day before. "Denied," she said. "This court retains jurisdiction. The interests of the child are this court's primary obligation." Denied. That single word settled the room like a door closing firmly on something that had been left ajar. After the hearing, my boyfriend's father approached me for the first time since Michigan Avenue. His attorneys were behind him, not flanking him, just present. "You've created an exposure that didn't need to exist," he said. "I've created a record," I replied. "That's different." His jaw tightened almost imperceptibly. "You could have been comfortable." "My child will be protected," I said. "That's more important than comfortable." Something moved in his expression then. Not anger exactly, something more like recalibration. He was looking at me the way people look at a situation they've misread and are only now beginning to understand correctly. He turned and walked out without another word. My attorney touched my arm gently. "You did well." "I let the court do its job," I said. "That's all." The DNA results came back in 2 weeks, exactly as everyone had understood they would. My boyfriend was the father. There was no revelation in the finding, only formality. But formality matters. Once paternity was legally established, the case moved from what everyone understood to what the state recognized. Those are 2 entirely different things. My attorney called me the morning it was docketed. "We moved to financial disclosure compliance now," she said. "The full picture." And that picture, when it emerged page by page over the following weeks, was considerably larger than the one painted in a 41st floor office. My boyfriend's annual compensation, when structured through salary, bonus, equity vesting, and trust distributions, placed him in the highest tier of state support guidelines by a significant margin. My attorney walked me through it across her conference table with a printed chart between us. "Under the statute," she said, "support is calculated to ensure the child shares proportionally in the parenting parent's standard of living. For someone at this income level, the court has discretion above the cap. The projected total was more than double the $3 million offer. And unlike a one-time payment, it was recurring, adjustable, enforceable, and tied to verified income that could not be quietly restructured." My boyfriend called that evening. His father's board had seen the disclosure filings. "This is bigger than I thought," he said quietly. "That's because your father calculated based on what he thought I'd accept," I said. "Not based on what your daughter is entitled to." A pause. He hadn't heard that word before. "Your daughter. It's a girl?" he asked. I had just found out. I hadn't told anyone yet. "Yes," I said. Silence on the line, but it was different from the silences before. Less defensive, more absorbing. He didn't say anything for a long moment. Then he said, "I'm sorry for the way this started." I didn't respond immediately. I've learned from working in an emergency room that not every silence needs to be filled. "Show up," I said finally. "That's what matters now." The final support hearing was held on a cold morning in February. I was 7 months along. The courthouse smelled like it always did, floor cleaner and recycled air, and the particular quiet of people waiting for outcomes that will change their daily lives. My attorney sat beside me with her binder tabbed and organized. My boyfriend sat at the opposing table. His father was present but seated behind him, no longer flanked by a full legal team. Just one senior attorney. Pressure has a way of simplifying presentations. The judge reviewed the disclosures methodically. "Financial records have been verified," she said. "Income figures are not in dispute." She began outlining the calculation: base support obligation, healthcare coverage, childcare provisions, educational funding, life insurance requirements. She spoke without drama, just structure, just a person explaining the law clearly. The 18-year projection was entered into record. My boyfriend's attorney noted his client's willingness to comply voluntarily with all court-ordered obligations. The judge acknowledged it. Then she said something I wrote down on the legal pad in front of me. "A child is not a liability to be managed," she said. "She is a responsibility to be honored." This court's function is to make sure that distinction holds. When we walked out, there were no cameras, no reporters, just the cold February air and the sound of traffic on the street below the courthouse steps. My boyfriend approached me outside. He was alone, without his attorney, without his father. "I should have made different choices," he said. "Yes," I replied. Not harshly, just honestly. "I keep thinking," he said slowly, "about what it would have been like if you'd taken the money." I looked at him. "It would have been simpler for you," I said. "But not for her." He nodded once. "I know that now." His father was waiting by the car at the curb. He saw me look toward him. He walked over. He stood a foot away and looked at me with the expression of a man who has finally finished an argument he'd been losing for months. "I made decisions based on protecting the company," he said. "I made decisions based on protecting my daughter," I replied. "One of us was right." He didn't argue. He extended his hand. Not as a negotiation, not as a formality, just as an acknowledgement. I shook it. That evening, my attorney and I sat in her office reviewing the final support order. Everything was in place. Structured monthly payments, educational trust contributions, healthcare coverage, life insurance with my daughter named as beneficiary. "You know," she said, "most women in your position accept the private offer." "I know. What made you different?" I thought about my mother in a warehouse on the night shift. I thought about the 19-year-old in the ER who didn't make it, and the ones who did because someone showed up correctly and refused to take shortcuts. "Private settlements depend on goodwill," I said. "Court orders depend on law." I don't know what his goodwill will look like in 10 years, but I know what a court order looks like. She smiled. "And the law outlasts moods." My daughter was born on a bright afternoon in March. 6 pounds, 14 ounces. The most alarmingly small thing I had ever held, and I hold people for a living. My boyfriend was in the room. He'd asked to be, and I'd said yes, because whatever he was to me by then, he was going to be her father, and that distinction was worth honoring. He held her the way people hold something they've underestimated the weight of, carefully, with both hands, like he was afraid of dropping something irreplaceable, which he was. His father arrived that evening. He came alone, no assistant, no attorney, carrying a small wooden toy that looked like it had been selected with actual thought rather than delegated to someone else. He stood at the foot of the hospital bed and looked at her for a long time without speaking. "She looks like him when he was born," he said finally. I didn't respond to that. I just watched him. "May I?" he asked, looking at me. It was the first time he'd asked me permission for anything. I nodded. He held her with the practiced awkwardness of a man who hadn't held an infant in 3 decades. He adjusted his grip twice, then he went still. I watched something move through his face that wasn't sentiment exactly, more like arithmetic completing itself. Like a number he'd been carrying wrong finally resolving into the correct answer. Later, when my boyfriend had stepped out to call his mother, his father and I were alone in the room. He stood near the window. Outside, the late afternoon light was going orange over the rooftops. "I offered you money to prevent this," he said. "Yes," I replied. He turned to look at her in the bassinet. "And I would have missed it," he said. "That wasn't something I'd accounted for." "Accountability works in more directions than people expect," I said. He was quiet for a moment. Then, "You were correct to file first." "I filed for her," I said. "Not against you." He looked at me with the expression of someone who has spent 60 years being the most powerful person in every room he entered, and has just, for the first time, met someone who genuinely was not impressed by that. "I know," he said. In the weeks that followed, something shifted that I hadn't predicted and didn't know how to name at first. My boyfriend started texting me about pediatrician recommendations. He asked about feeding schedules. He showed up to the 2-week checkup without being asked. These were not grand gestures. They were small, consistent, specific things that accumulate into something dependable. Pressure reveals character. I've believed that since my first year in the ER. When everything is calm, everyone behaves well. You see who people actually are when the situation requires something real from them. His father had responded to pressure by reaching for control. My boyfriend, under the same pressure, reached for responsibility instead. Those are different instincts, and they lead to different outcomes. My attorney noted it too when I mentioned it to her. Some people need structure before they can access accountability, she said. The structure is what makes the difference. 4 months after our daughter was born, my boyfriend's father called and asked if we could meet. In Margaret's office, I said. Neutral ground. He agreed without hesitation, which itself told me something. He arrived alone. No briefcase, no legal team. He sat across from me and my attorney and looked like a man who had spent the past several months thinking hard about something. I've been reviewing some things, he said. About what I thought I was doing versus what I actually did. He paused. I said nothing. I've learned that silence is often more productive than filling space. I built the company from a regional operation into something national, he continued. And for 40 years, every problem the company faced, I solved. I handled it. That became a habit. So when my son came to me, I applied the same approach. Assess the liability, contain it, move forward cleanly. He folded his hands on the table. But she isn't a liability, he said. She's my granddaughter, and I handled her the same way I would handle a zoning dispute. I waited. I'd like to establish an education trust for her directly, he said. Beyond the court requirement, not through my son. In her name. Her own. Why? I asked. Because I want to get this right, he said. And getting it right means she knows she was wanted, not despite everything, because of everything that came after. I looked at him for a long moment. You can do that, I said. He nodded once. He stood to leave, then paused. You filed first, he said. Yes. I was furious when I found out. He looked out the window briefly. But you were right. If you hadn't, none of this would be structured correctly. I would have found a way to settle it privately on my terms and convinced myself it was fair. It wasn't fairness you needed, I said. It was accountability. He looked at me with the particular expression of someone who has just heard themselves described accurately for the first time. Yes, he said. It was. It has been almost 5 years now. My daughter is in pre-K. She has strong opinions about which shoes she wants to wear and absolutely none about which direction her hair gets brushed. She is, in every identifiable way, her own person, which I find endlessly reassuring. My boyfriend moved to an apartment 12 minutes from ours when she turned 2. Wednesday evenings, alternating weekends, shared school events. We are not a couple. We are her parents, and we have figured out how to be good at that without requiring anything else from each other. That took work. It required a few difficult conversations and at least one mediator session. But it holds. The court order runs quietly in the background of our lives the way good infrastructure does. You notice it most when you think about what it would mean for it not to be there. Automatic transfers on the 1st of every month. Healthcare coverage that doesn't depend on anyone's mood. The educational trust that his father set up directly, growing steadily in her name. His father comes over on Sunday afternoons. He brings things she specifically requested, which is how I know he actually listens when she talks. Last month, she asked him for a book about bridges. He arrived with 4. He sat on the living room floor with her for 45 minutes while she informed him at length about which bridge was her favorite. He did not check his phone once. The first time she called him grandfather, he stopped mid-sentence and went very still. Then he continued talking, but he reached out and gently patted the top of her head, the way someone touches something they were almost not careful enough with, and now are. My boyfriend coaches her soccer team on Saturday mornings, which she takes extremely seriously, and he takes more seriously than she does, which is saying something. He is, genuinely, a good father. Not perfect, but present. Consistent. There. That's what the word means. I kept the original NDA in a kitchen drawer for about a year. Then I shredded it. Not out of resentment, just because I didn't need it anymore. It had done its job, which was to show me, with complete clarity, exactly what my options were and which one I needed to choose. The $3 million check expired uncashed. I watched the date pass and felt nothing except a particular kind of settled certainty. That number had looked like everything once. In the office on Michigan Avenue with the lake spread out gray and indifferent behind the floor-to-ceiling glass, it had looked like resolution. What it actually was, I understand now, was silence with a price tag. The court order doesn't have an expiration date. That's the difference. A woman I work with asked me once how I'd made the decision, whether it had been hard. She was going through something difficult. The kind of situation where the easier path and the right path are pointed in opposite directions and the distance between them feels enormous. I told her the truth. It was hard in one specific way. The $3 million was real. The security it represented was real. The easier morning it would have produced was completely real. I don't think acknowledging that is weakness. But I also knew something from years in the ER, which is that quick solutions to structural problems don't hold. You can stabilize a patient with the wrong intervention and feel good about it for a few hours right up until something goes wrong in a way that's much harder to fix. What works is correct treatment. What holds is right procedure. Filing was correct treatment. I don't tell this story because I think everyone's situation is the same, or because every choice that looks like the harder one is automatically the better one. I tell it because there is something that gets lost in conversations about money and power and private settlements, which is that the person being offered a large number to stay quiet is usually being offered it because the other party understands exactly how much more they stand to lose if the situation becomes public and documented. The offer itself is the evidence. What it's being offered to prevent is the information. When my boyfriend's father offered me $3 million in a 41st floor office, he was not being generous. He was protecting himself from a number that was larger. Once I understood that, the decision was easy. My daughter doesn't know the details of any of this. She knows that her father lives nearby and comes to her soccer games. She knows her grandfather brings her books and sits on the floor with her. She knows she has a mother who went to work before she was born and came home every time. That's the structure she was born into. Not because anyone felt warmly toward each other in the beginning, because the law required it, and the law held, and people, given enough structure and enough time, sometimes grow into the space that structure provides. His father said something to me once, 2 summers ago, watching my daughter run across the backyard at a birthday party he'd attended quietly, without announcement, without needing to be asked twice. "I built my whole life around controlling outcomes," he said. "And then you walked into a courtroom and reminded me there are outcomes that aren't mine to control." I looked at my daughter catching a bubble in both hands and laughing at the ceiling. "She wasn't an outcome," I said. "She was always a person." He watched her for a long moment. "Yes," he said. "She was. I just didn't understand that yet. Some things take longer to arrive than they should, but they arrive." Structure is patient in a way that good intentions rarely are. That's why it matters. That's why filing first mattered. Not because I was certain how it would go, because I was certain that she deserved to start life inside something that would hold, regardless of how anyone felt about it on any given morning. She does, and it does. That's enough.